Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup. In today's episode, we're going to discuss the results of the Trump administration's appeals of a January 11th, 2025 order issued by the U.S. District Court for the Central District of California to the U.S. Supreme Court. We previously covered this injunction in episode 40. The injunction that was previously in place, which involved the Fourth Amendment of the U.S. Constitution, forbid the government from relying solely on factors below, alone or in combination, to form reasonable suspicion for detentive stops for ICE to conduct immigration status checks. 1. Apparent race or ethnicity. 2. Speaking Spanish or speaking English with an accent. 3. Presence at a particular location, for example, bus stop, car wash, tow yard, day laborer, pickup site, agricultural site, etc., or the type of work one does. In the U.S. Supreme Court's undersigned 3-sentence, paragraph-long ruling that stands in stark contrast with prior rulings and the 14th Amendment's guarantee of equal protection and application of the law to all, the majority ruling simply stated, quote, Application 25A169 for stay presented to Justice Kagan and by her referred to the court is granted. The July 11th, 2025 order entered by the United States District Court for the Central District of California, case number 225-CV5605 is stayed pending the disposition of the appeal in the Ninth Circuit and disposition of a petition for a writ of certiorari. If such, a writ is timely sought. Should certiorari be denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. Attached, the court provided a more detailed concurring opinion from Justice Kavanaugh and a detailed dissenting opinion from Justice Sotomayor, joined by Justices Kagan and Jackson. Essentially, this means that at least until final ruling in the case is ordered, and at least in the Los Angeles area, as the opinion covers, but really nationwide, as the administration can argue, this opinion serves as legal guidance for nationwide application. Basically, they're stating that ICE can determine they have probable cause to stop individuals they observe in public doing things such as speaking Spanish, speaking English with a non-American sounding accent, appearing to have foreign ethnicity physically, appearing to have foreign ethnicity by the type of work they do, and the location where people are observed, to formulate probable cause to detain them to verify whether they're lawfully present in the United States. This ruling is in stark contrast to prior U.S. Supreme Court precedent in the 14th Amendment of the U.S. Constitution, which states in part, quote, no state shall deny to any person within its jurisdiction the equal protection of the laws. The Supreme Court's order, by stating that individuals who appear to be from the U.S. or speak English with American accents cannot be temporarily detained pursuant to the Fourth Amendment, but that individuals who appear to be foreign or speak a language other than English or speak English with non-American accents can be temporarily detained pursuant to the Fourth Amendment. Worse, the majority ruling provides zero guidance to lower courts on how the Supreme Court reached this ruling to guide cases in the future. This order appears to violate the 14th Amendment. all branches of government, including the judiciary, are bound to comport their conduct with the U.S. Constitution. I'm going to briefly quote some of Justice Kavanaugh's concurring opinion. Quote, "The Immigration and Nationality Act authorizes immigration officers to interrogate any alien or person believed to be an alien as to his right to be or to remain in the United States." 8 United States Code, Section 1357, subsection A1. Immigration officers may briefly detain an individual for questioning if they have a reasonable suspicion based on specific articulable facts that the person being questioned is an alien illegally in the United States. The reasonable suspicion inquiry turns on the totality of the particular circumstances. The government estimates that at least 15 million people are in the United States illegally. Many millions illegally entered or illegally overstayed just in the last few years. Illegal immigration is especially pronounced in the Los Angeles area, among other locales in the United States. The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants, and who do not speak much, if any, English. If the officers learn that the individual they stopped is a U.S. citizen or otherwise lawfully in the United States, they promptly let the individual go. If the individual is illegally in the United States, the officers may arrest the individual and initiate the process of removal. To stop an individual for brief questioning about immigration status, the government must have reasonable suspicion that the individual is illegally present in the United States. Reasonable suspicion is a lesser requirement than probable cause and considerably short of the preponderance of the evidence standard. Whether an officer has reasonable suspicion depends on the totality of the circumstances. Here, those circumstances include that there is an extremely high number and percentage of illegal immigrants in the Los Angeles area, that those individuals tend to gather in certain locations to seek daily work, that those individuals often work in certain kinds of jobs such as day labor, landscaping, agriculture, and construction that do not require paperwork and are therefore especially attractive to illegal immigrants, and that many of those illegally in the Los Angeles area come from Mexico or Central America and do not speak much English. To be clear, apparent ethnicity alone cannot furnish reasonable suspicion. Under this court's case law regarding immigration stops, however, it can be a relevant factor when considered along with other salient factors. Under this court's precedents, not to mention common sense, these circumstances taken together can constitute at least reasonable suspicion of illegal presence in the United States. Importantly, reasonable suspicion means only that immigration officers may briefly stop the individual and inquire about immigration status. If the person is a U.S. citizen or otherwise lawfully in the United States, that individual will be free to go after the brief encounter. Only if the person is illegally in the United States may the stop lead to further immigration proceedings. Now I'm going to briefly quote some of Justice Sotomayor's dissenting opinion. Quote, "In early June, the government launched immigration enforcement raids across Los Angeles and its surrounding counties. During the raids, teams of armed and masked agents pulled up to car washes, tow yards, farms, and parks and began seizing individuals on site, often before asking a single question. A federal district court found that these raids were part of a pattern of conduct by the government that likely violated the Fourth Amendment. Based on the evidence before it, the court held that the government was stopping individuals based solely on 4 factors. 1, their apparent race or ethnicity. 2, whether they spoke Spanish or English with an accent. 3, the type of location at which they were found, such as a car wash or bus stop, and 4, the type of job they appeared to work. Concluding that stops based on these 4 factors alone, even when taken together, could not satisfy the Fourth Amendment's requirement of reasonable suspicion, the district court temporarily enjoined the government from continuing its pattern of unlawful mass arrests while it considered whether longer-term relief was appropriate. Instead of allowing the district court to consider these troubling allegations in the normal course, a majority of this court decides to take the once extraordinary step of staying the district court's order. That decision is yet another grave misuse of our emergency docket. We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work in a low-wage job. Rather than stand idly by while our constitutional freedoms are lost, I dissent. In early June, the government launched Operation At-Large in Los Angeles, deploying roving patrols of armed and masked immigration agents to local car washes, Home Depots, tow yards, bus stops, farms, recycling centers, churches, and parks. Over the course of the next month, the government made nearly 2,800 immigration-related arrests and detained many more. For instance, on June 9th, immigration agents arrived at a tow yard in Montebello carrying handguns and military-style rifles. Jason Gavidia, a Latino U.S. citizen, was working on his car in the tow yard that day. A masked agent ordered Gavidia to stop right there and began asking him questions. Agents then asked Gavidia whether he is an American at least 3 times. 3 times Gavidia affirmed that he is. Unsatisfied, the agents asked Gavidia for the name of the hospital in which he was born, and when Gavidia could not immediately recall, the agents racked a rifle, took Gavidia's phone, pushed him up against the metal-gated fence, put his hands behind his back, and twisted his arm. Agents released Gavidia only after he offered up his real ID. That ID was never returned to him. The government, and now the concurrence, has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to agent satisfaction. As the district court found, and the government does not meaningfully contest, the present evidence reveals that the operation at large seizures occurred based solely upon the 4 enumerated factors, either alone or in combination. The Fourth Amendment imposes limits on search and seizure powers in order to prevent arbitrary and oppressive interference by enforcement officials with the privacy and personal security of individuals. Whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person, and the Fourth Amendment requires that seizure be reasonable. As relevant here, officers may stop an individual only if they are aware of specific articulable facts together with rational inferences from those facts that reasonably warrant suspicion that the individual may be illegally in the country. This requires more than an inchoate and unparticularized suspicion or hunch of criminal activity. In Brignone Ponce, for example, the court held that Mexican ancestry alone did not constitute reasonable suspicion to support stops by Border Patrol agents, even near the border, because large numbers of native-born and naturalized citizens had the physical characteristics identified with Mexican ancestry. So too, in Brown versus Texas, the court held that standing in an alley in a neighborhood frequented by drug users did not rise to reasonable suspicion because that activity was no different from the activity of other pedestrians in the neighborhood. The Fourth Amendment thus prohibits exactly what the government is attempting to do here: seize individuals based solely on a set of facts that describes a very large category of presumably innocent people. As the district court correctly held, the four factors, apparent race or ethnicity, speaking Spanish or English with an accent, location, and type of work, are no more indicative of a legal presence in the country than of legal presence. The government, joined by the concurrence, brushes aside this court's precedent with an appeal to probability, arguing that the high prevalence of undocumented immigrants in the Central District should enable agents to stop a relatively broad range of individuals. Without even a citation, the government asserts that 10% of the population in the Central District is unlawfully present, so it is inevitable and unremarkable that immigration officers would target any Latino person or any person speaking accented English or any person standing in a particular type of location or any person working a low-wage job in the greater Los Angeles area. Never mind that nearly 47% of the Central District's population identifies as Hispanic or Latino. Never mind that over 37% of the population of Los Angeles speaks Spanish at home and over 55% speak a language other than English. Of course, aggregate statistics cannot substitute for the individualized suspicion that the Fourth Amendment requires. In fact, the court rejected a similar argument levied by the government in Brignone Ponce. There, the government asserted that it could stop drivers of apparent Mexican ancestry in border areas because most undocumented immigrants in those areas are Mexican and most leave the border area in private vehicles. Unlike today, the court there rightly rejected the government's rationales because they would cover a large volume of legitimate traffic as well. Without any suspicion that a particular vehicle is carrying undocumented immigrants, the government's broad statistical approach to reasonable suspicion would subject the residents of these and other areas to potentially unlimited interference with their use of the highways solely at the discretion of Border Patrol officers. Rather, the court found that reasonable suspicion required additional factors, particularly one specific to a given vehicle or individual, such as the driver's behavior, whether the vehicle is heavily loaded or has an extraordinary number of passengers, or whether the officer observes persons trying to hide. The concurrence relegates the interests of U.S. citizens and individuals with legal status to a single sentence, positing that government will free these individuals as soon as they show they are legally in the United States. That blinks reality. Two plaintiffs in this very case try to explain that they are U.S. citizens. One was then pushed against a fence with his arms twisted behind his back, and the other was taken away from his job to a warehouse for further questioning. More fundamentally, it is the government's burden to prove that it has reasonable suspicion to stop someone. The concurrence improperly shifts this burden onto an entire class of citizens that carry enough documentation to prove that they deserve to walk freely. The Constitution does not permit the creation of such a second-class citizen status. The court's order is troubling for another reason. It is entirely unexplained. In the last 8 months, this court's appetite to circumvent the ordinary appellate process and weigh in on important issues has grown exponentially. Its interest in explaining itself, unfortunately, has not. Some situations simply cry out for an explanation, such as when the government's conduct flagrantly violates the law and when lower courts and litigants need guidance about the issues on which they should focus. The Fourth Amendment protects every individual's constitutional rights to be free from arbitrary interference by law officers. After today, that may no longer be true for those who happen to look a certain way, speak a certain way, and appear to work a certain type of legitimate job that pays very little. Because this is unconscionably irreconcilable with our nation's constitutional guarantees, I dissent. Keep following Executive Coup for further updates on this matter and others related to the apparent executive coup attempt that is unfolding in the U.S. federal government at the direction of President Donald J. Trump. with potential co-conspirators in Congress and the federal judiciary. Thank you.